One cannot turn a blind eye to the flip side of the criminal justice system. The continued detention of the poor, uneducated prisoners can have severe impact on her or him. And the Supreme Court directed for the constitution of the UTRCs in all the districts of the country in 2015, after taking note of the acute overcrowding in prisons, and NALSA's standard operating procedure for UTRCs was given judicial imprimatur in 2017. However, the issue of under trial prisoners languishing in prisons despite being eligible to be reviewed for release have continued to come up before the Supreme Court as well as the High Court. The National Crime Record Bureau data shows an overall prison occupancy of 130% as of December 2021, where 334 prisons were occupied by more than 150%. 44 had an occupancy rate as high as 300% or more, and 10 were about 400%. NCRB's data also shows that around 18 lakh persons admitted in the prison in a year, which also reflects the huge unflow of the under trial prisoners. Our responsibility as judges is to ensure that the law is followed in letter and spirit, and it does not discriminate between anyone on the basis of the quality of legal representation they can afford, among other man made qualifiers. This responsibility is also the bedrock of rule of law and access to justice. In the last few months, we have passed several directions establishing crucial digital frameworks and procedures to ensure smooth flow of information between the different organs of the criminal justice system so that there is no delay in processing the filing of appropriate legal recourses once the prisoners become eligible. One cannot turn a blind eye to the flip side of the criminal justice system. The continued detention of the poor, uneducated prisoners can have severe impact on her or him and the family and affects adversely in future. In fact, I have found it is this section of society which is more prone to detention, and the people who are able to afford appropriate legal assistance invariably get bail at an earlier date. It's this aspect which we seek to tackle in this process. Detention today is a view in the context of development. The extensive use of detention before conviction diverts criminal justice resources and exerts financial and employment burden on the accused and their families. This is recognized in the 2030 Agenda for Sustainable Development adopted by the United Nations in 2015, wherein number of under trial prisoners in proportion to the overall prison population is an indicator towards progress in achieving the Sustainable Development Goals, target 16.3, that is, to promote rule of law and ensure equal access to justice for all. The UTRCs are therefore a crucial body in fulfilling the central premise of leaving no one behind of the 2030 Agenda for Sustainable Development. The inclusion of access to justice in 2030 Agenda is recognition of the intrinsic link between access to justice and the ability of the people to receive equal treatment under the law and have their rights protected. The UN Principles and Guidelines on Access to Legal Aid in the Criminal Justice System 2012 affirms the legal aid and is a foundation for the enjoyment of other rights, and thus an effective legal aid system is important for the promotion of inclusive and sustainable growth strategies. A demonstrable reduction in the number of unsentenced prisoners is implied measure of progress in the context of the SDG indicator 16.3.2. India's Under Trial Review Committee is thus a unique mechanism in this context, being a district level body that is mandated to review the cases of prisoners periodically, recommended for release where it operates. After all, we can't have a scenario where we perceive that the only punishment which can be delivered is keeping people at the under trial stage, irrespective of whether the prosecution has the ability to get their conviction ultimately. This is a disturbing trend, which I find, where people remain behind bars under trials, and the presumption is whether they are able to get conviction or not. This is what may be the punishment or sentence. It is in this backdrop that the NALSA has decided to launch the UTRC Special Campaign 2023. I am delighted to note that the previous campaign titled Release UTRC at 75, undertaken from 16 July to 13th August 2022, led to identification of 74,107 prisoners who were eligible to be reviewed by the UTRC, out of which 47,618 were recommended for release, and subsequently 37,220 prisoners were released in pursuance to the campaign. That campaign was designed in the background of COVID-19 pandemic and had some additional categories of prisoners case for review. The present campaign is focused on the 13 categories of under prisoners as given in the NALSA, SOP, and the UTRC. The basis for putting this campaign for a time-bound schedule is that on a particular aspect of legal aid, there is concentration by all stakeholders for that period of time to achieve a particular objective. I would like to emphasize that success of this campaign rests upon shoulders of the executive chairman and the member secretaries of the state legal services authorities, who must lead this initiative with fervor in the respective states and UTs. I am confident that you will undertake the activities outlined in the campaign documents with diligence and promptly instruct the secretaries of the district level service authorities. Your rigorous supervision during the campaign will ensure its success. After all, the whole thing is to work from upwards level. That is, start at the base level and move upwards. And that is the whole premise of NALSA. At the end, I wish to share three key components of any campaign: preparedness in terms of groundwork, adherence to the timelines, and robust reporting. Wish you all the best for this campaign, and I'm certain that your efforts would create a lasting impact on the accelerating the regular functioning of these UPRCs. Thank you very much.